Now, we'd like to commence the first session of our conference under the topic of ICLS 10th Anniversary Roundtable, Looking Back and Looking Forward. His Excellency PAIK Jin-Hyun, former President of the International Tribunal for the Law of the Sea, will moderate this session. And Judge Beck, now the floor is yours.
Thank you. Good morning, distinguished colleagues, dear participants. It is my great pleasure to welcome you all to the first session of the conference, the special roundtable celebrating the 10th anniversary of the International Conference on the Law of the Sea, ICLS. As Vice Foreign Minister said in her remark, over the past decade, this conference has grown into a key platform for exchanging views and exploring new ideas relating to issues of contemporary law of the sea. Today we are here to reflect on the law of sea in the past decade and to look forward to the challenges and opportunities that lie ahead. Today I am honored to be joined by three distinguished panelists who could bring their expertise and insights to our discussion. To my left is Sir Michael Wood. Sir Michael is a leading practitioner of international law. He was a legal advisor to the United Kingdom's Foreign and Commonwealth Office. He was also a member of International Law Commission. Further to my left is Professor Natalie KLEIN. Professor KLEIN is a professor of international law at University of New South Wales, Faculty of Law and Justice, Australia. Previously, she was the Dean of Macquarie Law School in Australia. Finally, the third panelist is Professor Alex Wood ELFERINK. Professor ELFERINK is a professor of international law of the sea at Utrecht University in the Netherlands, and he is a director of Netherlands Institute for the Law of the Sea, NILOS. I will organize this roundtable as follows. First, I will pose a common question to the entire panel. All three panelists will be invited to respond to this question briefly, about a few minutes. Next, I will pose individual questions to each panelist, and each panelist may be given about 10 minutes to respond to that question. And finally, I will conclude with another common question to the entire panel. After this, I will open the floor for a question and answer session with the audience. I will try to make this session as interactive, engaging, and open as I can. Now let me start. Here is a common question for the entire panel. The question is, what do you consider the most significant developments in the law of sea over the past decade? Could you each identify 2 or 3 key developments and briefly explain why you believe they are particularly important? So each of you will be given about 3 to 5 minutes to respond to this question. May I start with Sir Michael?
Thank you very much, Judge Peck. And thank you very much to the Korean Society of International Law, to the Ministry of Foreign Affairs, and to ICLOS for organizing once again this excellent ICLS. I think ICLS is another acronym along with ICLOS and UNCLOS that becomes part of Law of the Sea discourse. So you've asked an impossible question. The most significant developments in the law of the sea over the past decade, but I'll try. And the first development I would mention is not really a recent development, and it's not really a development. It's the continuing and enhanced consolidation of UNCLOS as the basis for the law of the sea. President Haider said much about this in his keynote address. Note that I've avoided referring to it as a constitution for the oceans. I really don't like that phrase, even though it comes from very high authority and is of great antiquity, like since 1982, because I don't think there is such a thing as a constitution for the oceans, and using that term introduces, has consequences which I don't really agree with. As you can see, Mr. Chair, I'm going to try and be a little bit controversial and disagree with some of the things that others may say. Let's recall that the negotiations of the third conference leading to UNCLOS took place some 50 years ago. I would place 1975, 1976 as key dates, which is when there was broad agreement among states in the exclusive economic zone negotiations and the basic acceptance of that concept by states who started to implement it even from those dates without waiting for the conference to come to a conclusion. So we're dealing with law that's 50 years old, in a sense. Since the conclusion of UNCLOS, however, in 1982, there's been a remarkable degree of stability in the law of the sea. Stability which has nevertheless allowed for necessary adaptations to meet modern changes. But it's very important to strike the right balance between stability and adaptation, and to ensure that changes go along together with the grain of the law of the sea. To do this, in my view, requires both understanding and care. And for the most part, that's given. Though there are cases where you get proposals being made, for example, quite often in Brussels, which don't seem to have any relationship to a proper understanding of the law of the sea. But I'd just like to be a little controversial from time to time. And I think there's no one from the European Union here. A second development to which I attach great importance, I think we all do, again has been with us for a long time, but it's continued to grow in strength over the last decade, and this is the continuing success of the dispute settlement procedures under UNCLOS. And I would emphasize that it's not only under UNCLOS, it's not only under Part 15 of UNCLOS, but more generally that dispute settlement in the law of the sea continues to thrive. And I would also make the point that it's not only ICLOS, it's not only ICLOS and the ICJ, but it's also the very important contribution that a whole series of ad hoc interstate arbitrations have had under the law of the sea. As you all know, UNCLOS tends to favor arbitration. It's the fallback position, even though the presidents of ICLOS have been very skillful in seducing states to come away from arbitration and take their case before ICLOS. That's a very good procedure. When you fail to reach agreement on who the arbitrators should be, you're required to go and see the president of ICLOS, who helps you, and he comes up together with you after consultation with a panel of arbitrators who happen to be very similar to the judges of ICLOS, so you decide that a chamber of ICLOS would be a very good solution, or even a very large chamber, or even ICLOS itself, as happened in at least one case. So we mustn't forget, I think, dispute settlement not based on Part 15, but based on other things. And there's been many cases at the ICJ, including recently, that fall into that category. And also dispute settlement through arbitral tribunals. And also, I would mention, through conciliation commission, at least the one between Timor-Leste and Australia, which was a very successful way of resolving a dispute. So that's my second point in a way, but I would say that the importance of dispute settlement is not just to settle disputes. The decisions generally do succeed in resolving the dispute, but at the same time, and a good example of that, for example, is Enrique Lexi, which is a very difficult dispute, bringing great tension between India and Italy, and the dispute settlement procedures brought the states together with considerable ingenuity, I would say, reached a conclusion that satisfied, I believe, both states in that case. So that's a good example of a successful resolution by a dispute settlement body. I would also mention perhaps some more controversial matters, the special chamber in Ghana, Côte d'Ivoire, and indeed the full chamber to begin with, about the exploitation of in a disputed area before delimitation, led to some quite controversial but nevertheless helpful findings. And your own separate opinion, Judge PAIK, is quite interesting in that regard. I would say even, and I dare to mention it here, the South China Sea case, which superficially may be thought to have failed, given the reaction of one of the parties, in fact clarified a number of very important points. And I would just mention one, the relationship, for states parties at least, between the rules set forth in UNCLOS and conflicting pre-UNCLOS law, for example, on historic rights. That was a very important aspect that was clarified, I think, and I think correctly, in that case. And then a third development, which I'll be very brief on, because I feel I have to mention, the BBNJ agreement. I would be thought badly of if I didn't mention it. It's undoubtedly a remarkable achievement, but I'd like to add a word of caution. It remains to be seen how positive this new treaty will be. And I think the jury is out still on how far the BBNJ agreement really does go with the grain of the law of the sea, or whether it might not even, in certain respects, be disruptive. I hope not, but much will depend upon how it's interpreted and applied in practice. So those are my recent developments. Thank you.
Thank you, Sir Michael. I pose the same question to Natalie. Natalie, you have about 5 minutes maximum.
Sure. Thanks very much, Judge PAIK, and I join with Sir Michael in also thanking the organisers for the opportunity to attend the conference and engage in the discussions. I'm glad you mentioned the BBNJ agreement. I think it is very difficult when you think of significant developments in the last 10 years not to pay attention to a new implementing agreement that has been adopted under UNCLOS. But like Sir Michael, I'm going to mention it in passing and concentrate on 2 other developments that I think are significant. One is ongoing, and that is the discussions relating to a new code being adopted at the International Maritime Organization that will deal with maritime autonomous surface ships, so the MAS code, which should be adopted soon and will ultimately become a binding instrument. And I think that's an important development because frequently the law of the sea has had to run along behind with technological developments and then try and regulate once we have a sense of what that technology is and its implications for the law of the sea. But I thought the MAS code is particularly interesting because it has caused us to stop and think about questions which should be self-explanatory within the law of the sea, but suddenly we find ourselves asking, what is a ship? What is a warship? What does it mean to have sovereign immunity when you are something that resembles a shark that has been motorized? So I think the MAS code is interesting because it is causing us to look at these questions that are quite fundamental. It's making us think about how the law of the sea can respond to new technological developments. And I think it's also just the tip of an iceberg in dealing with this issue because it is very much focused on commercial autonomous ships that travel on the surface. But we know that this technology is expanding well beyond that particular purpose. And I think we still have a lot of other questions to answer, particularly about their use in maritime security settings. So I thought particularly of that issue as one that is progressing quite well, but still has some interesting work to do. And the other major development I wanted to mention might seem a little tangential in a way, but I wanted to highlight the adoption of a conservation and management measure by the Western and Central Pacific Fisheries Commission that deals with the question of forced labour. So that particular conservation and management measure will not come into force until 2028, potentially the same time the mass code comes into force. But I think it is emblematic of another significant development in the law of the sea in the last 10 years, which is to bring a much greater focus to the question of human rights at sea. I mean, well back in the early days of the International Labour Organization, seafarers were singled out in a bad way in terms of not receiving the same protections as other workers. And certainly once we had the Titanic sink, then we started thinking much more about safety of life at sea. But it seems it's been in the last 10, really 20 years that we have focused a lot more on the fact that there are a number of different humans who are working and travelling by sea. Certainly mass migration by sea has also brought these issues into sharp relief. And I think the interesting development here is that it is forcing us to think a lot more carefully about how the law of the sea interacts with international human rights law. And when we start thinking not just those fascinating questions about what is a ship, and that's very much a law of the sea question, but we have to think about how our principles of jurisdiction under the law of the sea can then work with how human rights lawyers think about jurisdiction. Then there are many more developments to contemplate. And this conservation and management measure, I think, is important because it did start a conversation thinking carefully about the scope of flag state jurisdiction to deal with their fishers on board, thinking about state responsibility when they're accruing or manning agencies in different jurisdictions, and thinking potentially what port states and coastal states can do in this area. So again, I think it's another development that has come a long way in the last 10 to 20 years, and I think that we're going to be seeing a lot more of it into the future as well.
Thank you. The same question goes to Professor ELFERINK. So Alex, you also have about 5 minutes.
Yeah, thank you, Judge PAIK. I also would like to join the other speakers in thanking the Minister
Speak
for...
into the microphone.
Yeah, I'll move over a little if this is better, I assume. So I would also like to thank join the other speakers in thanking the Ministry of Foreign Affairs of the Republic of Korea and the Korean Society of International Law and the International Tribunal for the Law of the Sea in organizing this conference and putting together this the excellent program we have. When thinking about this question the first question we have been posed, I was wondering whether we could come up with the same list and if there would be some repetition. To some extent that's the case, but still my list is at the same time also different from those of the two previous speakers. So my list concerns climate change, the South China Sea arbitration and the BBNJ agreement. So climate change and its impact on the ocean, of course, it's largely an issue of addressing human activities on land. At the same time, the impacts on the ocean are multifaceted and diverse. To start with, ocean acidification and rising seawater temperatures require putting more effort into enhancing the resilience of the ocean. And I would say primarily through addressing other sources of pollution, part of course from addressing the impacts of climate change and trying to limit climate change, and also by addressing it by establishing a coherent network of marine protected areas. And that also, of course, brings into focus the BBNJ agreement. Sea level rise is another issue related to climate change, of course, results in disappearance of islands and receding coastlines. From a law of the sea perspective, the law on this point is in development. The ILC and the ICJ advisory opinion have both submitted that baselines in principle may be frozen if they're established in accordance with the law of the Sea Convention. I would say at the same time the question remains whether there is a need for further development of the law on this point. For instance, should there be a review mechanism of baselines that have been established by coastal states in accordance with the general perspectives offered by the International Court of Justice and the International Law Commission. Also, of course, an issue of related to climate change, marine geoengineering. Of course, the question there is what regulatory regime should be put in place for this activity, and should it, of course, go ahead at all? And of course, there's also equity considerations in this connection. Who benefits from specific marine geoengineering access, and who is most effective, and whose voice should count most in decision making in this respect? Turning to the South China Sea arbitration already mentioned, I would say it has critically developed the law as contained in the UNCLOS on a number of points. And just let me give some examples. It's certainly not exhaustive. Of course, there's the interpretation of Article 281 offered by the South China Sea arbitration, which of course to some extent differed from the interpretation offered by the tribunal in the Southern Bluefin tuna cases, although I would submit that if you really look closely at the reasoning of the tribunal in the Southern Bluefin tuna cases, the distinction is maybe less pronounced as a lot of commentators have suggested. Of course, the South China Sea arbitration has also significantly contributed to the interpretation of the environmental provisions of the UNCLOS, and as already mentioned earlier by President Haider, this contribution has, among others, been recognized by the ICLOS in its advisory opinion on climate change. And of course, also very significantly, the interpretation and application of Article 121, paragraph 3 of the UNCLOS on the entitlements of so-called ROCs. Of course, in this case, there is a tension with state practice. If you look at state practice, it, well, seemingly does not seem to accord completely with the pronouncement of the tribunal. And there's also practice of states calling upon China to implement the ruling of the tribunal. And that, of course, raises certain questions, I would say, about the coherence of the law and also the credibility of those states calling upon China to follow up on the outcome of the award. I would say perhaps most importantly, the arbitration has put into focus China's systemic challenge to the UNCLOS-based ocean geopolitical seascape in the South China Sea by not, in a sense, wanting to accept the implications of an outcome of the geopolitical division of the South China Sea based on the rules contained in the law of the Sea Convention. Finally, briefly on the BBNJ agreement, I very much agree with Sir Michael that this is very much, of course, a work in progress. We're still waiting for the entry into force of the agreement. At the same time, I would say that in a number of respects, it's a significant elaboration of the UNCLOS. I won't go in any detail here, happy to elaborate subsequently. And so I also asked myself the question, how will it perform in practice after its entry force? And I would say it's also critical that it attracts more states as parties. Currently, at least when I checked the last time, and a couple of days ago, there are 75 parties, but quite a number of significant states are currently missing. And I would say it's really essential that those states also become parties to the agreement to make it work successfully and in harmonization with other international frameworks and bodies. Thank you.
Thank you very much for your observations on the first question I posed. I understand that there is interpretation, simultaneous interpretation from English to Korean. Therefore, if you slow a little bit your remark, it will be much better to interpret English into Korean. Now, let me move to the individual questions for each panelist. Let me start again with Sir Michael. The question I want to raise with you is UNCLOS and customary international law. It has been more than 3 decades since UN Convention on the Law of the Sea entered into force in 1994. However, still more than 20 states remain non-parties to UNCLOS. In a case involving such non-parties, of course, it is customary international law, not UNCLOS, that applies. What do you think is the customary international legal status of UNCLOS today, particularly in relation to Article 76, of course, which deals with the continental shelf, and Part 11, which deals with area beyond national jurisdiction, especially Article 136, addressing common heritage of humankind. In this regard, I refer to the extended continental shelf claim made by United States, of course, non-parties to the Law of the Convention, in December 2023, and more recent executive order issued in April this year, entitled Unleashing America's Offshore Critical Minerals and Resources. So may I invite Sir Michael on this question?
Well,
we have about 10 minutes.
10 minutes.
Yes.
Very good, thank you. And thank you for those interesting and difficult questions. Had you asked these questions in 1982 when the convention was adopted, or in 1994 when it came into force, I think the answers might have been somewhat different. But at least now, we can say, I think, that the substantive provisions of UNCLOS are increasingly accepted by states as customary, as reflecting customary international law. And it's the acceptance by states that matters. But this has been achieved through very often decisions of international courts and tribunals, which have been accepted by states as correct statements of the law. Now, this is true even as regards those provisions of UNCLOS which were innovative in 1982 when the convention was adopted. Obviously, the customary status of the provisions of UNCLOS does not apply to most of the organizational and procedural provisions, which can only have effect as treaty provisions. These are about dispute settlement, about the establishment of institutions, and that's where the question about the common heritage of mankind and Part 11 becomes quite difficult, but I'll come on to that. Now, it does seem, from what courts and tribunals have said and what states have accepted, at least by their silence, is that most of the substantive provisions of UNCLOS are customary. Examples of provisions that may not have been regarded as customary probably weren't when they were negotiated and when they were adopted in 1982. A famous one would be Article 76, paragraph 1, on the extent of the continental shelf beyond 200 miles. That, I think, was quite novel in parts when it was adopted. Whether the remainder of Article 76 is customary international law or not, the very detailed and specific provisions for determining whether an extended continental shelf claim is valid, is customary international law, is still undecided and unclear in my view. It was expressly not looked at by the Tribunal in the case between Colombia and Nicaragua that we will no doubt hear about. Another example would be the provisions relating to archipelagic states, which were certainly quite novel when they were adopted, but which have rapidly, I think, become accepted as reflecting customary international law, perhaps even those that are very specific, with mileage for how long closing lines can be, etc., or archipelagic baselines can be. And a third point that I would draw attention to is the provision about islands, which are rocks under Article 121, paragraph 3. That, I think, was relatively novel, was novel when it was adopted, and the court nevertheless has held, and I don't think states generally question the holding that that provision is also now customary international law. There may be one or two states who would object to that, but among those directly concerned, for example, the United Kingdom with Rockall, that seems to be accepted. Now, I think this development, the fact that so many provisions have become customary law, is uncontroversial and indeed is generally welcomed because it makes sense with the law of the sea to have common rules applying to all states. And if you can get that way by concluding that provisions of UNCLOS are customary international law, that's, from a policy point of view, very satisfactory, because it's very difficult to have a law of the sea which applies differently to different states in most regards. Uncontroversial and welcomed, though the International Court's decision in Nicaragua, Colombia, concerning the customary international law relating to delimitation between extended continental shelves beyond 200 miles and the exclusive economic zone may be an exception. There are a number of academics in particular, but also a very small number of states who may contest that decision. I must declare an interest because I think it's a correct decision. I was acting for Colombia in that case. I also think it's a sensible decision. And in my view, anyone who wishes to argue the opposite will have an uphill task, perhaps even before ICLOS, but not for me to say what ICLOS would decide on this question. Another controversial question that touches on customary international law is whether baselines are ambulatory, which seems to be the traditional view and seems to me to be what UNCLOS essentially was understood to mean, or whether they can be fixed, at least in the case of sea level change. I'm not at all clear why sea level change should be regarded as special. In this regard, the United Kingdom's baselines have changed greatly, by miles, on the East Coast over the centuries, not because of climate change, but because of, for other reasons, I think because of tectonic plate movements and the like. But no one seems to worry about that. We only focus on climate change. There are some controversial things. The International Court seemed to confirm that UNCLOS doesn't require a state to submit updated charts under Article 16, but what that means in terms of safety of navigation and the like, I'm not sure. It seems a very odd way to look at it. Now, customary international law plays a major role still, because, as you've said, 20 states, and they're not, some of them are very important coastal states, in particular the United States, but also Colombia and others with sensitive offshore areas such as Israel are not parties to the Law of the Sea Convention. Therefore, it still plays a very important role. And I'll just address the 2 points that you asked about. As you've recalled, the United States finally made an extended continental shelf claim in December 2023. It did so following long and I think very careful preparatory work, and it seems to have made a genuine and I think essentially successful effort to keep as close as possible to the substantive provisions of UNCLOS. It's tried to apply the rules in Article 76 in good faith, I think. So the question, though, is, I suppose, whether as a non-party it's entitled to do that at all. I can't see any reason why it's not. But the real question is how it can do that without the institutional provisions of UNCLOS, which the US did sort of try to apply. It informed everyone, but the CLCS obviously cannot determine whether it has done its calculations correctly or not. So there's an issue there. But I think the US has done its very best with that declaration to follow the rules set out in the law of the sea. There's an issue whether it has to engage in revenue sharing under Article 82. That's an obligation which I doubt if that's customary international law, but nevertheless they're trying to have some sort of substitute for that. So I would say that the US was quite loyal to the Law of the Sea Convention in that application and to what it saw as customary international law, to its claim for an extended continental shelf. Now, your second question is perhaps something of a contrast. The US President's executive order, which you mentioned from April 2025, entitled remarkably, as they often are, Unleashing America's Offshore Critical Minerals and Resources, which applies not only to minerals in their own continental shelf, but also in the International Seabed Authority. And at first sight, that certainly appears to be contrary to the terms of UNCLOS, with the reference to the common heritage of mankind and all the provisions of Part 11 about the deep sea bed. And it raises a series of very awkward questions. But two stand out, perhaps. First and foremost, whether the United States, as a non-party to UNCLOS, is bound under customary international law to refrain from engaging in mining in the International Seabed Authority. I do recall that this question came up at a conference in, I think, 2020 in Kingston, Jamaica, when Judge Robinson took the position that, that the principle of the common heritage of mankind set out in UNCLOS reflected customary international law. I had to respond, and I was very cautious. I didn't take a position. I said that I thought no company would invest its money in deep seabed mining without the certainty of a contract with the International Seabed Authority would give. I believe, at least I hope, that that view is still correct, but we shall see. Article 136 proclaims the principle of the common heritage of mankind, the area and its resources of the common heritage of mankind. But that article, I think, has to be read together with the Part 11, the whole of Part 11, and the 1994 implementation agreement. The US has recently set forth its view that customary international law has not changed with the coming into force of the convention in this respect, and that seabed mining remains a freedom of the high seas for non-parties, or at the very least, if that's not correct, it says that it's a persistent objector because it has always maintained that position, which I think is true if you look at the record. This will obviously make a very interesting case if it ever gets to a court, so I don't propose to express any view on the state of customary international law. I would note, however, that James Kruska, a former US military lawyer, I think, published an article a week or two ago in the International Law Studies journal entitled "The US Executive Order on Seabed Mining is Consistent with International Law." And I would commend that. I think he makes a very good technical legal case for that position. On the other hand, if you look at the question from a broader perspective and consider the importance and impact of a principle like the common heritage of mankind, you could well see a tribunal coming to a different conclusion. It's often the case that technical legal arguments sound very good when you make them, but broader arguments win the day at the end of the day. There's a second aspect, however, to this question, which is perhaps more interesting, and that is that under UNCLOS, Article 139, states parties are responsible for ensuring that deep seabed mining carried out by their nationals is only carried out in accordance with UNCLOS. So it could be that if any, let's say a Dutch national, is involved in American deep seabed mining, the Dutch government has an obligation to ensure that that national complies with UNCLOS and not to allow it to engage in this activity. Again, I don't take a view, but I think that's a more practical way of challenging what might be going on, but we shall see. Anyway, I've spoken long enough, so I'll stop there. Thank you very much.
Thank you very much. I'm sure there will be some questions. Okay, now let me invite Professor KLEIN. The question I want to pose to you is maritime security and the law of the sea. Of course, there is no agreed definition of maritime security. The term security is notoriously an elusive term. However, maritime security is understood broadly. In that sense, threats to maritime security may be complex and diverse. My question is, to what extent has the law of sea, particularly UNCLOS, been effective in addressing or strengthening maritime security? Could you also discuss the latest development in this regard, in particular, legal controversies surrounding the increasing use of force at sea, both by non-state actors, such as Houthi attacks against merchant shipping in the Red Sea, as well as against non-state actors, such as recent United States actions against alleged drug traffickers in the Caribbean, and also lately in the Eastern Pacific. So you have about 10 minutes to address these big questions.
All right. Thanks very much, Judge PAIK. They are big questions. As a starting point, in terms of the effectiveness of the law of the sea in UNCLOS, just as a general matter, I mean, we have come a long way, as we now have certainty, for example, that the territorial sea only extends up to 12 nautical miles. We finally have agreement on the existence of the exclusive economic zone. And these were important issues that were sorted by UNCLOS. And I think that counts as an advance for maritime security, that we have certainty over the existence of these maritime zones and the allocation of rights and duties within those particular zones. And in some respects, we have known unknowns when we're talking about those maritime zones and maritime security as well. So there is, it feels like, an unending discussion about the legality of military activities in the exclusive economic zone, and we still debate the question of prior notification or authorization through the territorial sea, and we can answer those questions through UNCLOS, but in some respects those are just old debates now. I don't think that there's any suggestion that what we have in UNCLOS is unsatisfactory in and of itself, and there's some need to move away from that, sort of the position that we had in the 1950s and early 1960s. So there's much that good that has happened in terms of progress, but really where the challenge, or the various challenges now fall, is in how those existing maritime zones and the rights and duties in those zones apply in the different circumstances and in new circumstances, like the two particular cases that you mentioned. So with the situation with the Houthis as non-state actors undertaking violent measures at sea, the answers come not just from UNCLOS, but from a variety of different sources. And when we think about the attacks that the Houthis have taken following the Hamas attacks in Israel, and then Israel's response to that violence, and the Houthis' decision to then target ships that they saw as affiliated with Israel, then that has provoked a range of different legal questions, because when you have non-state actors that are targeting commercial ships, then perhaps we're just talking about acts of piracy that have happened. So when the Houthis send a helicopter onto the Galaxy Leader, a ship that was flagged to the Bahamas, that seemingly falls within the definition of piracy, except then we have to have a debate, again, a long-standing debate about the meaning of private ends when pirates are pursuing a particular course of action. So whether we consider that the acts of that are not specifically for financial purposes, whether that falls outside the definition of piracy, then becomes a question, and certainly there's been some push, Douglas Guilfoyle at the helm of that, to expand our understanding of for private ends, and even under Douglas's definition, I think we could say that there are instances of piracy here. There have been questions raised about whether the use of drones, whether they are surface ones or underwater drones that are being used to attack commercial shipping, whether they can fall within the definition of piracy as well. So again, to go back to my initial comments about how do we understand the operation of maritime autonomous vehicles under existing law is a challenge. So there are questions still about an existing definition of piracy that is prompted in this situation. Also, the attacks by the Houthi rebels may potentially raise questions about maritime terrorism. And we have a 1988 protocol or a 1988 Convention for the Suppression of Unlawful Acts Against the Safety of Maritime Navigation, where these sorts of acts can be criminalised. But the options for enforcement under the 1988 Convention are very limited. While the 2005 protocol to that treaty expanded the opportunities for enforcement, the problem we have with that treaty is that not many states have become parties to it. And I do think that is a lost opportunity for states in terms of improving responses to maritime security, that treaty has not been more widely adopted, or at least as widely accepted as the underlying 1988 Convention. But it would provide another means. But then the situation with the Houthis has an additional complex layer to it, because we also need to start thinking about them potentially being an organised armed group. And this then makes us start thinking about whether we are dealing with a situation of a non-international armed conflict. And if we are dealing with an organised armed group and that there is a certain level of hostilities that has been reached, then we need to ask ourselves, well, once we have these militant groups firing on particular ships, what responses are lawful under the law of naval warfare. And another problem that we have here is that the law of naval warfare does not speak very well to non-international armed conflicts, and there may be some debate to what extent it speaks at all. And I think we have a lot of work to do in articulating the rules around that. And certainly there is work being done in revising the San Remo manual, which was an important 1994 guide that was adopted. But we haven't had any recent treaties at all on the law of naval warfare since the Hague Conventions at the turn of last century. We are currently relying on different manuals that are being prepared by various institutions or interested practitioners and academics, and they are becoming our main point of reference in trying to determine what rules apply in this situation. And I think we need to ask ourselves to what extent that is satisfactory, or to what extent do states need to better engage on these particular questions. There's also a question about, with the Houthis, again, about the use of force at sea. And we also then start having questions about, well, when there is a use of force at sea, at what point does the right of self-defense apply? And I think we can recognize that there is a right of unit self-defense for a particular warship that has been attacked to be able to respond. Whether it goes so far as to constitute an armed attack and go to a right of self-defense under Article 51 of the UN Charter is then a more complicated question. And the guidance that we have to rely on is the jurisprudence from the International Court of Justice in the oil platforms case. But we're relying on really just a few sentences in that judgment to try and give us some idea about what the laws are in dealing with this. So I think one of our challenges at the moment is how these different bodies of law interact and how we respond to the use of force at sea. So the Houthis, I think, do expose in different ways some of the unanswered questions we have regulating the use of force at sea. When we start thinking about the use of force against non-state actors, as we're seeing currently in the actions that are taken against drug traffickers in the Caribbean and now apparently in the Eastern Pacific as well. Once again, the question of a non-international armed conflict seems to emerge because that has been a suggested justification for the United States actions. Yet here we have a difficulty because we're looking for a determination that there are hostilities, and when you're talking about drug traffickers, that just falls so far beyond the realm of what counts as hostilities, because it is delivery of a dangerous product into a particular country that ultimately has to get packaged, it has to be distributed, it has to be sold, potentially on-sold, before it finally reaches a consumer who might use it and then might be harmed. That is not the kind of hostility that we would expect to see for a non-international armed conflict. And equally, when we're looking for an organised armed group, some scepticism has been raised about whether the drug cartels are really so organised that they fall within the realm of an organised armed group. So if we don't accept that particular classification, then we start dealing with questions of maritime law enforcement. And though the United States is not a party to UNCLOS, in some respects it largely does not matter, because the rules around the use of force in the context of maritime law enforcement, we know from the Sega No. 2 judgment, are questions of general international law and require that the use of force is reasonable and proportionate, and that considerations of humanity are to be applied in this situation. And it seems when you have, I think at last counts, over 50 people who have been killed through the US law enforcement action, that we do have a problem in meeting that particular threshold. Indeed, we've gone well beyond it. And then we can also start questioning whether there are questions of human rights, and particularly the right to life, that is at stake here. And as I mentioned in my comments at the start, we have a challenge in bringing the law of the sea together with international human rights law. And under international human rights law, we look to see if a state is exercising effective control over particular individuals. And I understand the US has said that the ICCPR, the International Covenant on Civil and Political Rights, does not apply at sea. And if we say, well, we need a standard of effective control, do we have effective control when you have somebody policing from a distance and then firing rockets and other weapons to cause a vessel to sink? So there may be an interesting discussion to be had relying on the Human Rights Committee jurisprudence in the AS and Italy case, where for law of the sea lawyers it felt like quite a stretch in terms of saying that Italy was responsible because of the special relationship of dependency and the factual circumstances. Would we say that that standard is applicable here in relation to the United States, deploying its law enforcement officials and denying a right to life here? So there are very much difficult questions relating to maritime security, and these are questions in the end that go well beyond UNCLOS. And if anything, I think where we should have done more in terms of UNCLOS and in subsequent maritime security treaties, it is around the question of dealing with stateless vessels. Because the United States is partly relying on domestic legislation that it adopted back in 2008 that essentially criminalized stateless vessels. And we have typically avoided dealing with the exercise of jurisdiction over stateless vessels, both under UNCLOS and in other maritime security treaties, and just sort of referred generally to rules of international law. And maybe we needed to be a bit more explicit that actually when a vessel is stateless, there are still humans on board who have a nationality and are protected by their country of nationality, and that needs to be a consideration in how we deal with these issues. But as a question on the use of force, really I think the statements from the Sega decision, which in turn drew on much earlier jurisprudence from the Red Crusader, and the I'm Alone case holds good and should really be applied when we're assessing the legality of the conduct in this situation. But I'll leave it at that. Thank you.
Thank you. Thank you. Now I would like to invite Professor ELFERINK for responding to my question. My question is concerned with the scientific and technological developments and the law of the sea. This aspect has been already mentioned by Natalie. I think science and technology have long driven the evolution of the law of the sea. Since the adoption of UNCLOS in 1982, scientific and technological advances have accelerated, presenting new legal and regulatory challenges. Often, scientific and technological developments create uncertainties in the existing law, thus leading to its revision or its replacement with new laws. My question is this: how well has the law of sea, particularly UNCLOS, responded to these developments? I may refer to the challenges arising from, for example, maritime autonomous ships, which Natalie mentioned, climate change impact. In fact, Alex, you already mentioned this yourself, and deep sea marine bioprospecting, and other innovation that test the limits of the current legal framework. In this regard, do you think there will be any limit to the evolution of UNCLOS? Sir Michael mentioned something like a grain of the convention. So what is your view on how far the convention can evolve in responding to these challenges? So you have 10 minutes.
Thank you, Judge PAIK. I would say that there's not one single answer to your questions. I would say it depends on the nature and of the scientific and technological developments, the state of the law at the time of their occurrence, and the response of states. And let me walk you through a number of examples to illustrate these points. First of all, the implementation of Article 76 of the UNCLOS, dealing with the definition of the outer limits of the continental shelf. At the time of the adoption of the UNCLOS, it was considered that the continental shelf beyond 200 nautical miles would be a relatively straightforward process, only involving around 40 states. Advances in science and also seafloor mapping arguably made the process of gathering and assessing the relevant information that needs to be submitted to the Commission on the limits of the continental shelf to substantiate the outer limits of your continental shelf much more complex. And this, of course, was not only an issue of science and technology, but also an issue of capacity for states from the global south. The 10-year time limit for making submissions to the CLCS was problematic for many states. A number of solutions were considered in that respect, were set out in a note of the Secretariat of the United Nations. Doualos prepared that, offering a number of solutions. And in the end, this was before the meeting of states parties twice, and basically the meeting of states parties opted for a practical solution that largely seems to have been successful. Another topic I would like to briefly touch upon is seabed mining in the international seabed area. And maybe that's an example of scientific knowledge lagging behind the development of the activity concerned. Exploration areas in the Clarion-Clipperton zone in the Pacific already were assigned before there was knowledge about the seabed environment and biological diversity. And only subsequent to the awarding of exploration areas, the ISA proceeded to identifying areas of particular environmental interest, so-called APIs. These were first considered in a working group involving scientists, and they also included a number of exploration areas, partly in the areas of particular environmental interest. After a review by the ISA, that no longer was the case. It's not completely clear why that happened, but one might speculate that the ISA didn't want to touch upon existing exploration rights of states, although from an environmental perspective, that might have been justified. So this points to the need to have effective environmental standards in place prior to activities moving ahead. And perhaps the BBNJ agreement could contribute to doing this in the future by inter alia establishing a network of marine protected areas, and also by the provisions of the BBNJ agreement on strategic environmental assessments in areas beyond national jurisdiction. Again, turning to baselines and sea level rise, in this case I would say science, but also including legal scholarship at an early stage pointed out that the UNCLOS might not provide an adequate framework, and that's due to the fact that at the time it was considered that under the convention baselines are ambulatory. Well, this early identification of this issue arguably left sufficient time to respond, and there has been both developments in state practice and both also in the advisory opinion of the International Court of Justice, also the work of the International Law Commission. And so the international community seems to align on solutions in this case that are also likely in line with a specific interpretation of the UNCLOS. You can have questions about that. interpretation, of course, with the original intentions of the drafters of the convention. As I also observed before, there remains the question whether there should be further reflection on the development of the law. And in this connection, of course, Sir Michael already pointed out the fact that sea level rise or climate change induced sea level rise and changing baselines is singled out from other developments that impact on baselines. And the question is, what provides the justification for doing so? If you look at the UNCLOS framework. Marine genetic resources, science put it on the agenda, but the debate on the regulation was also driven by the existing legal framework. And of course, that's first of all, of course, the general principles contained in the UNCLOS. And so the question arose, of course, how the regime to be developed would relate to the regimes of freedom of the high seas and the common heritage of humankind. And also another question, how would it relate to intellectual property rights? And also another question is, where should this issue fit, in the UNCLOS or the CBD? Because I think you can make an argument that both options initially would have been possible. So very much a question here of the existing legal frameworks and of course also the choices that states make in this respect, impacting on how the law further develops. So to conclude, as I said at the outset, I would say the impact of science and technology on the law depends on these three issues: the nature of scientific and technological developments, state of the law at the time of their occurrence, and the response of states in developing the law. And different interests obviously point in different directions in that connection. Thank you.
Thank you, Alex. We have completed this second round of question and answers. But before I move to the final round, which will be brief, does any panelist respond to the comments made by other panelists? Just briefly. Nobody? Okay. All right. Then I will move to the third and final round. This is concluding question for the entire panel. Looking ahead, my question is this: looking ahead, what do you see as the most serious challenge facing the law of the sea in the coming decade? How should the legal framework respond to that challenge? In light of this, do you have any suggestions or recommendations for the future agenda of the International Conference on the Law of the Sea? I understand there are many postgraduate students attending this conference. Do you have any suggestion for the PhD topic of PhD dissertation for those postgraduate students? So this is question. You have about 3 to 5 minutes to respond to this question. Again, start with Sir Michael.
Well, thank you very much, Judge PAIK. I see you put this in the singular, the most serious challenge. But I was going to mention 3 things. First, very briefly, I fully agree with what Natalie said about the need to look at the interface between UNCLOS, or the law of the sea, and military activities, with the view of the review of San Remo Manual, the application of IHL. But I suppose this is more a question of jus ad bellum and jus in bello than it is of law of the sea, but nevertheless, law of the sea lawyers should look at it. So I agree with that. A second, rather technical, but I think very important weakness at present is flag state jurisdiction. This, of course, comes up in many fields, for example, the human rights of seafarers and even passengers on board cruise ships. Flag state jurisdiction is particularly weak in many respects. And it's come up particularly just in the last few weeks. If you read Egil Talk, for example, with articles about attacks on subsea cables and pipelines, including sometimes what may be what may be deliberate attacks on them in the Baltic, and decisions of the Finnish courts, for example, that look very narrow in what jurisdiction may be taken up. I think this is a big question, but I won't go into depth. Now, the main answer to your question is that I think a possible topic, but it would be controversial, for a future conference, for a future ICLS, could be something like, is there a need for more caution on the part of dispute settlement organs under the law of the sea? And under this heading, topics might include the role of state consent to dispute settlement, even where a treaty provides for jurisdiction. For example, the need for a proper understanding of the limitations and optional exceptions in Part 15 of UNCLOS. Secondly, and this is perhaps the main question I have, the risk of advisory opinions being sought inappropriately and or even being misunderstood. I won't go into the Mauritius, Maldives jurisdiction judgment, but I have to say I disagree with it fundamentally. And I can say on that occasion I had nothing to do with the case, so it's a very neutral view I take. If you remember the history, the Sub-Regional Fisheries Commission case, ICLS unanimously arrogated to itself, because there was nothing in the treaty, a power to give advisory opinions at the request of anybody other than the International Seabed Authority, which is provided for in the treaty. Then that was on a fairly narrow issue, and the ICLS was quite careful in defining what its role was in relation to that narrow issue and the scope of its advisory opinion. But then, in a completely different level, as it were, we had the climate change advisory opinion, in which a small group of, was it 9 states, asked a question that was relevant to all states. So, are we going to end up with a situation where 2 states can get together, form an organization, and ask a central question, for example, whether the passage of warships through the territorial sea needs permission or not? That would be a very dangerous question to ask any court, so I hope no one will. But it's possible under the current approach of ICLS for that to happen. So I think this was not challenged in later cases, in the climate change case, this jurisdiction. It was taken as a given. But the one thing that was said by a number of states is that it would be important for ICLS to define the circumstances in which it will, and the conditions under which, and the effects of which such advisory opinions might be given. Now, I can understand that a court doesn't like to define its own jurisdiction in advance or its own powers in advance, but nevertheless, I do think it's a pity that the opportunity wasn't taken so far to define and clarify what the scope of these advisory opinions of ICLS are. So I think that it's important to look that states should take care. If not, the effect could be that states may even withdraw from UNCLOS if they find that dispute settlement provisions are going the wrong way. We've already got the question of withdrawal from from the European Convention on Human Rights because of dissatisfaction with judgments of the European Court of Human Rights. That's very active. 2 principal political parties in the UK have that as part of, or say that's going to be part of their manifesto for the next election. So it's a real risk, and I think state organs and states, of course, who are behind these tribunals when they ask questions, do need to take care. So that's my suggestion for a possible topic for a future conference. Something like, is there a need for more caution on the part of dispute settlement organs acting under the law of the sea. Thank you.
Thank you. So, Michael, now I'd like to invite Natalie for your response to my question. 5 minutes.
Yes, thank you. Well, I would like to invite myself along to Sir Michael's conference that you're proposing. I think that there is much to talk about on that particular issue. In terms of a future conference, my thoughts were on this question that I have been pondering in different ways around the interaction of law of the sea with other bodies of law, and I think it's really important as people interested in the law of the sea to make sure that we do engage with, or really outside maybe outside our comfort zone, but certainly in relation to other areas of law, and certainly the two issues I've talked about today really expose that, I think, in relation to the connections with international human rights law, as well as the connections with the jus ad bellum and the jus in bello as well, and a need for us to look much more closely at how that operates with the law of the sea. So I do think there is work to be done on that area. In terms of the most serious challenge facing the law of the sea, I think it is, I kind of put it at an existential level, because I think there is a grave disservice being done predominantly by international relations scholars when they persist in talking about grey zones and talk about the rules-based international order. I would just like for us to articulate far more clearly what the law actually is, and to ensure that the law is actually part of a dialogue that goes on in policy decision-making. I feel like there is a need for us as lawyers to be able to stand up quite decisively and say what the particular rules are. And honestly, if the rules are ambiguous, then that is a clarion call to try and bring certainty to the area. Or if there is a gap in the law, equally we need to work to fill that gap. That is, of course, inordinately difficult at the moment in our current geopolitical setting. But if there was one thing I think we need to do in terms of responding to this serious challenge of the ongoing relevancy of the law of the sea, is really to make sure that we continue to engage and articulate very clearly what the legal rules are and how they apply when we're dealing with these different scenarios, and making sure that it is still part of the dialogue and not getting drowned out by more policy-oriented approaches. I can't believe I'm sounding like a born-again positivist, but this is where we have gotten to. So I will leave it at that.
Thank you. Now the same question goes to Alex. You have 5 minutes.
Yeah, thank you, PAIK. I'll try to be brief, like the other speakers. Most important challenge, maybe, as I already mentioned before, the contestation of the UNCLOS, and that's not only by China in the South China Sea, I would say, but among others also the other example provided, US unilateral mining outside of the conventional framework. How should the legal framework respond to that challenge, this contestation of the UNCLOS? I would say it's not so much a question as to how the legal framework should respond, but rather states will have to determine how they want to respond. And of course, those responses have to be formulated in a very complex geopolitical setting these days, so that makes it very challenging to decide how to factor in law of the sea issues in your broader overall interests. Any recommendations for the future agenda of the ICLS? I would say it would be interesting to look at the legal scholarship, international relations, governance scholarship interface. What do these different disciplines have to tell each other about contestation and how regimes develop? Thank you.
Thank you. Thank you very much for 3 panelists. This will complete the question and answer for the panel. Now I want to open the floor for a question and answer session with the audience. Now it is your opportunity to engage directly with the panelists. We have about 10 to 15 minutes. Here we have really a table full of food for thoughts. I'm sure there will be a lot of questions. ICLS, so President of ICLS first.
Thank you very much for an excellent panel. Very complimentary, very good comments made. Sir Michael has this rare talent of prompting me to speak in conferences, and just want to make two comments. First, on the advisory jurisdiction, I think in comparing the SRFC advisory opinion and the climate change advisory opinion, I think they are equally global. So even though the tribunal in the SRFC advisory opinion focused on the obligations of flag states with respect to IUU fishing in the 7 exclusive economic zones of the West African coastal states, it is quite clear that these obligations apply equally globally to other regions as well. So I think I don't think we should compare them the way you did, Sir Michael. I think the climate change is just similar in terms of globalness. Now it's interesting that, of course, following the SRFC advisory opinion, there were some states that questioned the existence of the advisory jurisdiction, especially at the meeting of states parties in New York. So it's very interesting to then compare that and contrast it with the reception that the advisory opinion on climate change received last year. So I had the pleasure of presenting the opinion at the meeting of states parties last year, and again for the second time this year for even more discussion. And I think there were only 2 states that questioned the existence of the advisory jurisdiction as such. So this means there's a lot of progress in the general recognition of the advisory jurisdiction of the tribunal as a whole. Now, I think there's a very important aspect here in terms of, I don't think it is realistic to expect that the tribunal can set out in detail conditions for what kind of questions would be admissible for advisory opinion in the future. We need to have a certain amount of flexibility. There can be all kinds of various questions that it's difficult to foresee what could be. The important part here is that the tribunal has the discretion. And the discretion described originally by the tribunal in the SRFC advisory opinion was that it should give an advisory opinion unless there were compelling reasons to do otherwise. If you look very closely at the climate change advisory opinion, and I'm not sure all academics who have been studying it have realized this, but if you look very closely, you will see that there is a certain departure from the requirement of compelling reasons. So this means that the tribunal now considers that it has even more discretion to deny giving an advisory opinion than was the case before. So I encourage everybody to look very closely at the advisory opinion of last year, and if you make a comparative study with the advisory opinion on the SRFC request, then you will see a certain difference. I think it is quite relevant. For the tribunal, it is important to ensure credibility, and this is why we need to use our discretion power very carefully. And so I'm with you there, Sir Michael. I think that is very important to keep the trust of states parties. The other comment I wanted to make has to do with this question from Nicaragua, Colombia. So this general question of whether state A can, its claim of entitlement to an outer continental shelf can extend into a 200-mile zone of a state B, a neighboring state. So the tribunal has not dealt with this question generally. It did deal with this question in the particular context of the Bay of Bengal area in Bangladesh, Myanmar. It could have had the opportunity to do so in Mauritius, Maldives, but it avoided the question there the way the equidistance line, the provisional equidistance line, was adjusted in the second stage of the delimitation of the exclusive economic zone and continental shelf up to the 200-mile limit, meant that the question was made moot. So we did not deal with the question in that case. There have been some articles in the literature suggesting that the tribunal in Mauritius, Maldives, did somehow support the same conclusion as the ICJ in Nicaragua, Colombia, but that is not the case. We have not dealt with this question generally. We will see in the future what our answer is going to be if we will be asked this question. I mentioned in my speech this morning that I mentioned examples of very positive examples of cross-references and complementarity between ICLOS and the ICJ in particular, but there are also potential examples, at least, of inconsistency. And we will see, I don't want to speculate about how ICLOS would answer this question. I don't think we should speculate about that. We should just see and wait and see what we will say if we receive this question in some form in the future. Thank you very much.
Thank you, Judge Haida. I don't think these are questions, but anyway, later, if you want, I may give you opportunity to respond briefly. Professor Lee.
Thank you, Judge PAIK, for giving me the floor. My name is Keung-Kwan Lee, and I'm teaching Public International at Seoul National University, and I'm a member of the UN International Commission. And I'd like to express sincere thanks to all the panelists. And even though this session doesn't title itself that way, but I think this session worked as a kind of plenary session for the whole conference, and thank you very much. And my question, well, because I'd like to raise all these questions to all the panelists, but at the same time, for the benefit of time, I'm going to exercise self-restraint, and I limit myself to raising some questions to Sir Michael. And two questions. First of all, in your presentation, you said that you're not fond of the expression, a well-known expression, the UNCLOS being a constitution for the oceans. I know, I can guess why you think of, take this expression that way, but for the benefit of, in particular, all these young students who are gathered here, can you elaborate on this point a bit further? And my second question goes to the recent US practice in relation to Part 11 of UNCLOS, and thank you very much for enlightening us about this very important recent development. And my question is, the fundamental question is, so my question to you is, how do you evaluate? Can you be kind enough to provide us with your own assessment of the international legal status or normative status of common heritage of mankind? I'm raising this question because if you look at Article 311 of UNCLOS, there is a paragraph 6 which grants a rather special status, inter partes at least, to be fair, but at the same time it grants a special status, elevated status to this common heritage of mankind principle. And then, of course, I'm sure that you are familiar with the draft conclusion 17 on the identification and legal consequences of use cogens. There, let me just quote, certain rules relating to common spaces, in particular, common heritage regimes, may produce erga-omnes obligations independent of whether they have peremptory status. So again, I would appreciate it greatly if you can elaborate on this normative status of common heritage of mankind at this current moment. Thank you.
Thank you. Shall we take one or two more questions before I give you the opportunity to respond to save time.
Hi, my name is Leanne, and I'm from Seoul National University, a master's student. Thank you very much for this engaging talk. My question is pertaining to Pacific Islanders specifically. As Sir Michael has briefly talked about the change in the baseline due to rising sea level in the case of UK with tectonic change, but in Pacific Islanders specifically, it's more about climate change, and I feel like it's more of an urgent issue in terms of its having an existential consequence for some, because like in the future decades, there might be like some nations that might disappear due to that change in sea level. So what is the role of UNICLOS in this regard, and how do they delegate like what happens to the stateless refugees that happen due to climate change, and what is the future of that specifically? Another thing that I was pondering is what was UNICLOS's effort or role in terms of like the refugees seeking asylum during the height of the Syrian civil war refugees that were going through the Mediterranean Sea, and whether there is any laws pertaining to the protection of such refugees? Thank you very much.
Thank you. Sir Michael, today is your day. There are too many questions for you. Finally, I saw, yes, one person down there. Question for other panelists, I hope. Okay. Yes, this will be the last question.
Thank you very much for accommodating me. I'm Irvin Jules Sape, representing the Philippine International Law of the Sea Academy, or PhilSea, as Executive Director, and in alignment with Konrad Adenauer Stiftung Rule of Law Program Asia. Comment and question related to each other. So my first comment is that I really acknowledge Professor KLEIN's comment for encouraging lawyers to stand up when we see policymakers are, pretending to know really the law. But I've also came from the Manila Dialogue on the South China Sea, and we have this Vietnamese friend and colleague requesting the policymakers to invite lawyers of the sea so you can have a more concrete understanding of international law as well as the UNCLOS regime. So my question is, for Professor KLEIN, is that how do you think policymakers and lawyers of the sea can cooperate and coordinate with one another for the due regard obligation to address military activities and exclusive economic zones? Thank you.
Thank you very much. Now, I'd like to invite the panelists to respond to the question raised. Shall we start with Sir Michael?
I suppose we shall. Firstly, I would like to endorse everything Natalie said, of course, but particularly questioning this term rules-based international order, which politicians use all the time, which I think is nonsense. It's a way of avoiding referring to international law. And as lawyers, we should say what we need to apply is international law. The Chinese put it with with a bit of humor, I think, when they says they don't believe in a rules-based international order. What they believe in is an international law-based international order. And I think that's quite a good way of putting it. I'd like to clarify to President Haider that I wasn't seeking to question now the position of the advisory jurisdiction of ICLOS as it's developed. I was just describing it as part of the background to then my further question about it would be good to have greater clarity. And I fully understand his answer on that point. Of course, it's very difficult for courts to anticipate the future. But nevertheless, with a little ingenuity, or perhaps writing outside the judicial field, it might be possible to help states a little bit to understand the circumstances in which, as you've explained, and it's very interesting, this greater discretion that you foreshadowed in the climate change opinion might be used. It would be very interesting to know further about that. Now, I was asked why I didn't like the term constitution for the oceans. I just don't like the term constitution. I mean, we're not used to it very much in the UK, since we don't really have a written constitution anyway. But I don't like, for example, when the UN Charter is referred to as a constitution. It's not a constitution in the domestic sense of the word. It doesn't carry all kinds of implications. It's a treaty, like any other treaty, and it means what it says. It can't be interpreted in a constitutional way, in my view. So that's, I think, the danger of this expression. So I would try to avoid it, though, of course, it's a very catchy thing to say, and Tomiko said it, so it's very important, of course. I was asked again about the assessment of the current status of the common heritage of mankind, whether it's customary international law or not. I really don't want to add anything to what I said before. I did say that this article by James Kraska, I thought gave some very convincing legal arguments for why it was not customary international law binding on the United States, either because it's not customary international law or because they're a persistent objector. But nevertheless, I don't want to take a position because cases may come up and I don't know which side I'm going to be arguing on. So that's why I said very clearly I'm not taking a position on this matter at all. So I'm sorry to disappoint you on that. But the reference you made to the ILC's draft conclusion 17 and its 2022 draft conclusions, which are still draft conclusions because they haven't been attached to a General Assembly resolution yet, on Jus Kogan's. All I can say is I think that was very carefully drafted, and it says may, and it doesn't really say very much, which shows that it was carefully drafted, that commentary that you quoted. Now, I've probably omitted to answer something, but I'll stop there and I'll leave it to my colleagues to answer.
Okay, Natalie?
Well, I might jump in with a couple of questions that were directed to you on the existential crisis for Pacific Island states in relation to
no interest.
Baselines. You know, the law of the sea doesn't speak particularly well, I think, to deal with the very human dimensions of the reality of land becoming uninhabitable and eventually going undersea, because the law of the sea, you know, still has this old adage or principle of the land dominates the sea. And how can you claim, or how can a state claim maritime zones if it does not actually have any land from which to claim it? So the law of the sea is not entirely helpful in that regard. But there is a lot of work being done on the issue of climate migration and the issues that are being posed there. And I would refer you particularly to the work of the ILA Committee on Sea Level Rise, which did adopt a set of principles, I think it was in the Sydney 2018 conference, and the work of one of my colleagues, actually Jane McAdam at UNSW, who has written quite extensively on the relevant legal principles to deal with climate migration. And in terms of the law of the sea dealing with migration across the Mediterranean, I mean, UNCLOS itself really only has Article 98 in terms of a duty on flag states to require masters to render assistance to help those in distress at sea. But that obligation to render assistance is not absolute. The master still has to make decisions about whether it is, what the impact for the master and their ship will actually be. So you need to look at the Search and Rescue Convention and the Safety of Life at Sea Treaty. It's also dealt with as a migrant smuggling issue, but the important thing is the migrant smuggling protocol defers to the human rights issues that are also at play. in the end, we have about 4 different bodies of law that are relevant for addressing mass migration by sea, and the problem is the policy decisions that are made that tend to prioritise the application of one body of law over another. And we still have some loopholes to deal with in terms of the duty of disembarkation and what it means to be in distress and what a place of safety constitutes. So the law of the sea does talk to some of those issues, but there's also a strong role for human rights there. On the question around military activities in the exclusive economic zone and a role for lawyers in dealing with that particular question, I think it is important to differentiate between the types of military activities that are being undertaken, because I think there is a vast difference between like military manoeuvres with live exercise of and use of weapons versus the military activities of intelligence, surveillance and reconnaissance, because ISR, intelligence gathering, can happen while still showing due regard to the rights of the coastal state around fisheries or marine scientific research. But the moment that you're undertaking fairly complex military exercises, then there is a bigger question about the potential infringement on coastal state rights. There has been discussion in the literature about whether due regard involves notification or consultation, and you know, there's probably scope to talk about to what extent those 2 particular elements need to be taken into account in ensuring that the obligation of due regard is met. But I think it's very context specific as between the types of military activities and the coastal states' particular interests that are implicated by those particular activities. And it's going to be very location specific. So, you know, one example given was with Russia proposing to undertake military activities and was protested by Irish fishermen that it was right near one of their fishing grounds. I mean, that's quite a localised issue in the end, and Russia did actually move the military exercises in that situation. So the key thing in terms of lawyers and policymakers is making sure the lawyers are at the table for those discussions. And it's not just the principle of due regard that's at stake, it's also the non-abuse of rights that's also relevant in that setting too, which I think is important. And potentially, depending on the type of military exercises, also thinking about threats of use of force, and also what's not a threat of use of force, and what's not a violation of the peaceful purposes provision as well. Both of those have very high thresholds, and I think it's important for lawyers and policymakers to understand that.
Thank you. Alex, do you have anything to pick up?
Yeah, thank
Quickly.
you. Just very briefly on the rules-based order. I think maybe we shouldn't be too dismissive of it in the sense that it's a term that's being regularly used and also has different meanings. So I think as lawyers we should also be asking ourselves, how is it used and why is it used? And I think also, you know, I think that's relevant and not just dismiss it, because I think this is a term that's going to be around for the future. So I think it's important to consider its implications. Thanks.
Thank you. This brings us to the end of the first session. I would like to thank the 3 panelists again for sharing their thoughts and insights on the law of the sea in the past decade and in the decade ahead. I believe that our roundtable discussions this morning has provided a solid foundation and context for the discussion in the sessions to follow. Thank you.
Thank you very much. Once again, please give a big round of applause for Judge Beck for moderating this session and for all the speakers.